Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the March 17th, 2020 sitting of the Massachusetts Appeals Court. I'm Justice Eric Neyman, sitting today with Justice Catherine Hand and Justice Suk-Young Shin. Calling our first case on the list, Commonwealth versus Miller, docket 2020 P1101. We'll hear first from counsel for the appellant, Attorney Lindmark.
Good morning, Your Honors. May it please the court, I'm Attorney Lindmark, and I'm here on behalf of Mr. Miller today. This is an appeal out of the Woburn District Court. Our argument is based on allegations of ineffective assistance of counsel and the Commonwealth's failure to establish its case. Simply, trial counsel arrived in court for trial with no file, no discovery, no court-ordered records, nor any other substantive evidence to defend his client. His strategy, seemingly, to make an argument that the victim was lying. However, it's our position he had many potential tools in his toolbox, which he never used to support that argument. Perhaps most importantly, her cell phone records, including calls and text messages, were never obtained by counsel, never introduced into evidence for the judge to consider. Had he done so, it's our position that all of this might have turned out very differently. Here, as in, we've cited the case Commonwealth versus Elsider, here as there, better work might have accomplished something material for the defense in this case.
I'm sorry, what was the victim's position at trial?
The victim's position at trial was that he called her, she felt, from Chili's restaurant and made a statement to her. She said that she recognized his voice.
And what would her phone records, had they been introduced, have shown?
Her phone records would have shown there were two calls, apparently from Chili's restaurant, but there was no way to identify who made those calls. There was no record whatsoever who had actually made the phone calls. Police had gone to that Chili's restaurant that very day and spent quote unquote hours looking at surveillance tapes and never saw Mr. Miller on the scene.
Right, but wouldn't her phone records have arguably corroborated her testimony? It would have confirmed that she received two phone calls from a Chili's restaurant, as she testified to.
It would have confirmed she received two phone calls from a source unknown. She is saying that Mr. Miller called her, and however, it's our position, there's absolutely no record of that. He clearly did not call her from his cell phone, which is what she originally alleged. She changed her story 5 months later and said, in fact, he never called her from his cell phone. And there's no record that he was in the restaurant that day.
I guess the reason I'm asking is, couldn't it have been a strategic decision by trial counsel, and I acknowledge you were not trial counsel, obviously.
Mm-hmm. Yes.
A strategic decision to say, look, these phone records are going to confirm what she ultimately testified to at trial, and therefore there's no need or no desire for the jury to see them. Well,
it was actually a bench trial, and
you're right. So there was no reason for the finder of fact rather to see them.
Right. It's our position that in fact the records show more than she received two phone calls from Chili's restaurant. There were a series of phone calls being made to known numbers. However, trial counsel never investigated. He never actually obtained the cell phone records, sadly. He never hired any investigator, any private investigator, no experts to investigate who actually was calling who. It's also our position he should have requested the text messages. They could have been very telling as to who she was texting to and what they were saying just before and just after this alleged incident took place. In fact, it's my understanding her mother and her sister both lived in Burlington, and she was having ongoing communications with them. None of that, however, was ever investigated by trial counsel. He never obtained the surveillance tapes to see if any other known people had been in Chili's restaurant that day. He never obtained police notes from the officer who interviewed her. He never seemed to have conducted any interviews. Again, there were no experts and no private investigators on this case. Trial counsel also was seriously flawed at trial. During cross-examination, he never actually followed up with the victim about her change in testimony. She was never asked about her return trip to the police station 5 months later to change her story, the how and the why. This was a critical lapse. What was really going on in this case, according to the defense, according to Mr. Miller, it seems that the alleged victim was trying to, in her own flawed way, set him up by alleging he called her from Chili's. First, she said from his number, then another number. But when she discovered that the cell phone records were indeed ordered, she went back to the police station and changed her story. Would better work, ultimately, the question here is, would better work have accomplished something material for the defense? We would suggest strongly, yes. If her cell phone, yes.
Could I ask a question on a little bit of a different topic, but with respect to your argument that the failure to present the harassment protection order hearing transcripts was ineffective, can you explain that a little bit to me?
Well, she went to the Concord District Court first to make these same allegations. The judge there chose not to grant the restraining order, stating that it seemed to be a very sad situation, but not grounds for a restraining order.
But she didn't discredit the victim, correct? Or the plaintiff in that case. She indicated
didn't
that
discredit her. Correct. But then the alleged victim went to a different court, the Woburn court this time, and was able to get the restraining order. And we would just suggest that this was evidence that this was a woman on a mission. There was a long history between these two, unfortunately, and it was, I agree with the judge in Concord, a sad situation. The bottom line here is, though, that we believe counsel arrived at trial not prepared. He had done no investigation. He could not provide the quality of assistance that would be expected of a reasonably effective attorney. Mr. Miller's only real defense that the victim was lying, had a history of lying, and motive to lie was not explored. Reasonable doubt could have been everywhere. It was just never properly developed by trial counsel. That was his job.
Attorney Lindmark, it seems that you have a fairly strong position on the first prong of Safarian. And as you were starting to say, I think the challenge in this case is establishing the second prong. That's sort of the issue before this panel. With that in mind, I note that we don't have an affidavit from trial counsel. How does that impact your argument?
Trial counsel chose not to provide an affidavit as for whatever his reasons might be. I can't speak to that. However, I think
is that in the record before us?
I did at the end of the hearing with Judge Cremens, at the end of the motion for new trial hearing, provide that information to her.
Does that information
yes.
need to be provided in an affidavit, or is it sufficient to make that representation in court without more?
I think as an officer of the court, my statement should be accepted as on the record and in evidence. That would be my thought on that. So in sum, again, it's our position, the cumulative, the total effect of these failures to prepare, if you will, failures to prepare at all was to deny Mr. Miller his right to a fair trial, to competent advocacy at trial. And as in another case we cited in our brief, Commonwealth versus Haggerty, failure to investigate the only defense a defendant has, if facts known to or with minimal diligence accessible to counsel support that defense, falls beneath the level of competency that should be expected. Then as to issue 2, our position is quite simple, that the motion for required finding, if not guilty, should have been allowed. Reviewing the evidence, even in the light most favorable to the Commonwealth, a rational trier of fact could not have found the essential elements of the crimes beyond a reasonable doubt. We would suggest that for that reason, the motion for required finding should have been granted. Any other questions? No.
Seeing none, thank you, Attorney Lindmark.
Thank
We will
you.
now hear from the Commonwealth, Attorney Lee.
May it please the court. My name is Chi Lee, Assistant District Attorney for Middlesex on behalf of the Commonwealth. This court should affirm the motion judge's order denying the defendant's motion for new trial. First, I would like to clarify the standard review. The standard review to review the prejudice prong is not better work. SJC 2016, v. Million 474 Mass 474 Mass 417 has clarified that better work standard is not the correct standard. The standard is whether there's a substantial risk of miscarriage of justice in this case. In terms of the victim's records in this case would not have to serve to impeach the victim, but only to corroborate her testimony, because the records did show she received 2 calls from the Chili's restaurant, which is consistent with her trial testimony. To the extent that the defendant argues that this would go to the victim's credibility because she changed her statement to the police, the trial judge, who was also the motion judge, was able to evaluate the credibility of the victim witness. The victim testified on the stand that she received 2 calls from the Chili's restaurant, and she recognized the defendant's voice based on her prior interactions with the defendant, both in person and on the phone. The trial judge had also heard investigating officers' testimony. The defendant changed her statement to the police from receiving 3 calls, with 1 from the defendant's cell phone, to receiving only 2 calls from the Chili's restaurant. Defense counsel, unlike my sister suggested, actually cross-examined the victim on this change of statement on page 34 to 35 of the trial transcript. Trial counsel did cross-examine on this issue, although the victim denied that change of statement. Trial counsel did cross-examine on that. Trial counsel also brought up this change of testimony through the investigating officer on page 52 of the trial transcript. So these issues of credibility had already submitted to the trial judge, who was also the motion judge here. The text messages here only serve to corroborate the statement. And as Justice Neyman recognized earlier, this could have been a strategic choice if trial counsel had known the cell phone records. Admittedly, it was not provided prior to trial because the Rule 17 motion, although allowed, the records never came in at the time. However, even if it were provided at the time.
Interrupt you, Attorney Lee. So if the victim in fact did not change her story, what was the purpose of her going to the police station that day? And shouldn't defense counsel have cross-examined her about that?
Certainly. And the answer is the trial counsel did cross-examine the victim on this case on page 34 to 35 of the trial transcript. And the victim denied that change of testimony. She insists that she told the police that she received 2 calls from the Chili's restaurant on the day of the incident. However, that inconsistency in her testimony was brought up on both witnesses during cross through the victim herself and the investigating officer on page 52 of the trial transcript. So trial counsel did explore this issue, and the motion judge, in her ruling, page 8 of the order, did find that the trial counsel, quote, demonstrated a command of the evidence in his argument and response to the arguments. So the motion judge, who was the trial judge here, did make a finding about his representation of the defendant in this case, and found that his representation was proper based on her knowledge of the case, where she was the trier of fact. Where the trial counsel had explored the issues about the credibility of the victim witness, and where the cell phone records only showed to serve to corroborate her trial testimony, there was no error, there was no ineffective assistance of counsel based on this claim. And for the remaining 4 claims about ineffective assistance of counsel, those claims either lack factual legal support. About the hearing transfer to the Concord District Court of the harassment prevention order hearing, there was no inconsistency or there was no discredibility found by the judge in that case. The judge only found that there was insufficient 3 incidents to support issuance of the order. The defendant has not addressed, both in his motion or on appeal, how the transcript would have to serve to impeach the victim in any way or to serve to help his case in any way. That argument has not risen to the level of appellate argument. In terms of sufficiency, This court should affirm the conviction because the evidence was sufficient to show a violation of a harassment prevention order, where the victim testified she recognized the defendant's voice based on her prior interactions with the defendant, both in person and on the phone, and where the defendant volunteered a detail of the investigation prior to the officer identifying the name of the victim or any other detail of the investigation. The victim's statement alone is sufficient to prove the case beyond reasonable doubt. This court has the decision last year in COMMONWEALTH v. Santos. If there are no further questions, the Commonwealth rests on its brief.
Seeing none, thank you both. Thank you for the helpful